Discussion related to will and yeah, the discussion relating to will. Will is not subject matter here, unless somebody wants to.
Yes, I virtually concluded my submissions. Just I wanted to take my lords to some of the judgments that I have for various propositions. I have narrated the propositions and also set down below of each of them in my synopsis. That is filed on 15/12/2025. My lords may straight away come to page 7, my lords. Suraj.
It is not all, it's judgment number 11.
My lords, what in effect the petitioners are seeking, petitioner direct proposal, is that
Where they are put.
they should become seniors to the promotees who are promoted earlier to them. I have pointed out that 2 dates in 2015 by which they are promoted, and 2016 they are direct recruitment. That is the date on which they were appointed.
In between, there are some other persons who are directly recruited.
No, only one. This batch of the petitioner direct.
No.
Total there are
2016.
total in that batch 2016, 8 direct recruits were recruited, appointed. Only 4 of them have questioned it. What I wanted to submit through that is that it is not that suppose, my lords, in a issue like seniority, even if one person challenges and if he becomes, consequences should follow. But I only submit that 4 persons are obviously satisfied with the seniority granted to them. It is not that it is a large scale dissatisfaction that has led to the present petition. I am not saying that they are greedy, but I am only saying that out of 8 direct recruits, 4 have come before the court. And in essence, if I forget about their drafting and all that, reliance on authorities and all that, what they say is that they should get seniority above the promotees who were earlier promoted. Except saying that these promotions, the number of vaguely saying the 83 recruitment rules had a quota and all that. They do not specifically point out which promotion from 1983 is in excess of the quota. And it is left to the discretion of the learned judge, who said that 32 posts are in excess and all that. And I demonstrated that 32 posts would not make any difference insofar as seniority of promote is concerned. No, my lord, see, where the promotions are within quota or in excess of the quota, one thing that is settled is direct recruit cannot get seniority from a date anterior to his appointment. The position insofar as the promotees is slightly different. Suppose somebody is promoted on ad hoc basis, then the regular promotion is delayed. Notwithstanding the delayed promotion, If on ad hoc basis the promotee has continued continuously without break, then he would get seniority from the date of actual vacancy arising, though not from the ad hoc date. For that proposition, my lord, judgment number 14, that is Suraj Prakash Gupta, which I have referred at huh? volume 2 of the judgments, paragraphs 80 and 81. First judgment, the judgment number 14, that is at page 246, the judgment commences. Para 41, 42, 44 may be taken at the first instance, then 80, 81.
Volume 2.
Para 40 to 44, they deal with one of the issues raised because they say in All India Judges Association 3, Supreme Court said you amend the rule before 31st of March 2003. Therefore, that seniority has to be calculated not only on the basis of quota but also on the rota. Otherwise, it will be unworkable. Now, the specific question considered at paragraph 40 to 44, 43 or 44 is whether rota can be implied. Rule itself does not contain any rota. Rule contains only quota. Then whether rotational principle of seniority can be implied. That is, my lords, one rota, no express rota rule. That is how para 40 above it is titled at page 270 of the paper. This is how it starts. Rota, no express rota rule. We shall next refer to the contention of the direct approach that rota quota rule is to be applied. Before us, it is not disputed by the learned counsel for the direct approach that in the recruitment rule 78, there is only a quota rule and that no rota rule has been expressly prescribed. Question is whether rota can be implied. The direct approach contend that rota is to be implied or read into the quota rule. It is also argued that there has been a previous practice of applying a rota, and this fact stands conceded in the counter affidavit filed by the government in the SWP so and so. Reliance is also placed on the cabinet note of December 1797, where the view of the law department that quota rota rule is to be applied is referred to. In our opinion, in view of the admission before us by all parties that there is no express rota rule, the decision of the High Court that rota principle applied cannot be upheld. As held in NK Chauhan versus State of Gujarat by Krishnayar J, there is no question of quota being necessarily interlocked with rota. It is not necessarily inscribed within every quota rule. Again, in B.S. Yadav versus State of Haryana, Chandrasud Side held that a quota does not imply a rota. The first part of the contention of the direct approach is without any substance. Rota cannot be brought into only because of past practice. Here there was no past practice also, except a past judgment of the Supreme Court, which also made it subject to the amendment of the rule. So far as the second part of the contention is that there has been a previous practice, we may refer to L. Chandrakishore Singh versus State of Manipur. There it was held that a practice must be consistent with the rules and that a practice not consistent with the rules is not acceptable. In that case, the practice of not considering for promotion probationers and considering only confirmed candidates was held not consistent with rules and could not be permitted. Similarly, in D. Stephen Joseph versus Union of India, it was held that a past practice which was divorce a rule could be of no help. The question in that case was as to whether the requirement of a particular years of service with graduation for promotion meant service after graduation or service during which a degree qualification was acquired. A practice of counting 3 years after obtaining qualification was not accepted. In that view of the matter, second part also fights. Therefore, my response submission is a direction which is contrary to the rules to adopt rota when the rule itself does not contain rota principle cannot be countenanced. Of course, that relief also has not been granted, but since it is before the larger bench, I will have to be this one. Then para 80 and 81 in the same judgment, that is at page 284. Direct recruits cannot claim appointment from date of vacancy in quota before their selection.
Paragraph?
Paragraph 80, 81. We have next to refer to one another contention raised by the respondent direct recruits. They claim that the direct recruitment appointment can be antedated from the date of occurrence of a vacancy in the direct recruitment quota, even if on that date the said person was not directly recruited. It was submitted that if the promotees occupied the quota belonging to direct recruits, they had to be pushed down whenever direct recruitment was made. Once they were so pushed down, even if the direct recruit came later, he should be put in the direct recruitment slot from the date on which such a slot was available under the direct recruitment quota. This contention, in our view, cannot be accepted. The reason as to why this argument is wrong is that in service jurisprudence, a direct recruitment can claim seniority only from the date of his regular appointment. He cannot claim seniority from a date when he was not born in the service. This principle is well settled. N.K. Chauhan was a state of that later direct recruits cannot claim deemed dates of appointment for seniority with effect from a time when the direct recruitment vacancy arose. Seniority will depend on the length of service. This is very relevant, my lords. Seniority will depend upon length of service. Again, in A. Janardana versus it was held that a later direct recruit cannot claim seniority from a date before his birth in the service or when he was in school or college. In fact, my lords, in that judgment, Janardana, the language used is this, my lords. The promotees were in uniform when direct recruits were still in the school. And direct recruit can claim seniority only on the day he is permitted to wear uniform. What we have there then also, similarly, it was pointed out in A.N. Pathak secretary that slot cannot be kept reserved for direct recruits for retrospective appointments. What we have stated in point one is ad hoc assistant applies to ad hoc assistant to the extent the principles laid down are applicable. With this is point number 2. Then, my lords, the Cadre and Cadre strength notification, because one of the contentions taken, one of the findings recorded by Rajeshwari K is that honorable judges that the Cadre strength notification has not been issued by the state government. For that, my lords, it has been answered by Anu Shivramanje saying that no such notification is required. And then, my lords, I also pointed out, I placed before my lords, the judgment of the division bench of High Court of Kerala, in respect of which leave has been granted, no doubt, but there is no stay. As on that day, as on today, that is a good law. Unless something else of our High Court or Supreme Court contrary to that is pointed out. No such effort has been made in the writ appeal, though he may make an effort, then only after he makes an effort, I will have to answer that. Then, my lords, that is, the rules applicable have been produced and I have indicated the page numbers. Then, my lords, what is the meaning of the cadre? In service jurisdiction expression, cadre means the unit of strength of a service or a part of it as determined by the employer. I need not labor much on that. Then, my lords, a reliance has been placed on various civil service rules to say that in the civil service rules it is stated so and all that. And reliance is also placed by on MV Dikshit. MV Dikshit is in respect of a civil service dispute that arose under the Civil Services Act. In MV Dikshit, the question was whether upgradation and downgradation of a post can be done or cadre strength can be altered without following Rule 3 and Rule 8 of the Civil Services Act. That is answered by lots by judgment of this court in a writ petition, which I lost. that is one of CV Chitra versus State of Karnataka. That is judgment number 8 in my compilation. That is page number 121. There were two petitioners.
Just 1 minute.
In this case, not CV Chitra, the issue was this one.
Yes.
First National Judicial Pay Commission of Lordship Justice Jagannath Shetty recommended that for appointment as a civil judge, minimum experience of 4 years at the bar should be dispensed with. Then, my lords, if they also said what happens is if we allow them to practice for 4 years, if they become successful, they would like to continue as advocates. Therefore, we will get only substandard persons to man the judiciary. That was the reasoning of the commission. In this case, in our High Court rules, there are 4 in our rules, Karnataka rules, 4 years minimum practice as advocate is insisted upon. Then, what the writ petition filed by CV Chitra and her colleague was, in spite of the recruitment rules being contrary to the view of the recommended or desire of the Supreme Court, can the 4-year service practice in bar could be insisted upon? I relied on the judgment of the Supreme Court to amend the rules and all that. Then, my lord, this is what this honorable court held at paragraph 11, my lords, page 127. Recruitment of judicial officers. Could my lords get the page? Recruitment of judicial officers other than district judges to the judicial service of a state is governed by Article 234 of the Constitution of India, which reads, I will skip that, paragraph 12. It is clear from Article 234 that the governor of the state has power to make rules regulating the appointments to the judicial service after consultation with the State Public Service Commission and with the High Court. The impugned rules are made by the Governor of Karnataka in exercise of powers conferred by under Article 233 and 234. Article 233 deals with the appointment of as we are concerned with the recruitment of civil judges junior division. The relevant provision applicable is Article 234. Though the impugned rules also make reference to the proviso to Article 309 of the Constitution of India, as also to the publication of draft rules as required under Clause A of Subsection 2 of Section 3, read with Section 8 of Karnataka State Civil Services Act 1978. As rightly contended by the learned counsel for the respondents, the recruitment to the judicial service in the state being governed with the rules framed under Article 234 of the Constitution, after consultation with the High Court and the state public, neither Article 309 nor the provisions of Karnataka State Civil Services Act can regulate the exercise to be made by the governor in framing the rules for recruitment. Therefore, my lord, the civil service rules is thrown out of reckoning when we come to the recruitment and seniority of the uh, judicial officers. Then, my lords, proceeding at then the division bench quotes extensively from judgment of the three-judge bench in Balmukund Shah. Then, my lords, at paragraph 17, page 131. In that regarding the seniority of the application of reservation, Lordship Justice R.P. Sethi was in minority in that. Majority view is extracted here. The views expressed by the apex court in Val Mukund Shah's case, as referred here in above, fully and completely answers the contention raised by the learned counsel for the petitioners regarding the violation of provisions of section 32A read with section 8 of the Karnataka State Civil Services Act, section 23 of the Karnataka General Clauses Act, and article 309 of the prison. None of these provisions can control the recruitment and power of the competent authority, namely the governor of the state, to make rules in consultation with the High Court regulating recruitment to the post of Civil Judge Junior Division. Therefore, in the absence of any requirement under Article 234 of the Constitution requiring previous publication of the rules, such requirement cannot be read in by resorting to several legislative enactments. As the publication of the draft rules itself was not necessary, the alleged defects pointed out in the publication of the draft rules and in the omission to specify the date on or after which the draft rules will be taken into consideration will not vitiate the impugned rules framed by the governor of the state. Same thing applies to the cadre strength notification also, is my respectful solution.
But under the act, there must be some provision.
There is no, my lords, I read out, Karnataka Civil Courts Act is the provision. There, apart from, it says, for creation of the post of civil judge, notification is required. But such a requirement is absent for the post of district judge, because simple reason, it says every court of district judge shall be headed by a district judge. And if there is a court, there must be a district judge.
For government employees, what applies?
To the government employees, Article 309, and the rules made thereunder.
What are the rules that govern there?
In the government, my lords, what the rule says is Section 3 and Section 8 of the Karnataka State Civil Services Act. Section 3 of the Karnataka State Civil Services Act says, for
Civil Service Act.
Karnataka State Civil Services Act, first I'll just read out the provision. Provision of the Karnataka State Civil Services Act is Section 3, if my lords would take. It has to be by a notification. Section 3, subsection 1. Subject to the provisions of this act, the state government may by notification make rules specifying the different categories of posts in the different branches of public services of the state, the total number and nature of posts and in each category, and the scale of pay admissible to each such category. 3.1. Specifying the different categories of posts in the different branches, the total number and nature of posts, which are how many are temporary posts, how many permanent posts, all those things will have to be incorporated in the rules made by notification. There is no analogous provision in the Civil Courts Act, nor any rule has been made requiring that in respect of posts in judicial services. Except
Servants in the and officers of convention easily applies public service. Who is a public service? Just to yeah.
in fact, that act also I have placed at page 637 of the compilation, but now my lords are having the act itself. City Civil Courts Act.
ಇಲ್ಲ ಅಂದ್ರೆ ಇಲ್ಲ.
ಅದು ಇದೆ.
ಓದ್ಲಿಲ್ಲ.
But the
Proviso.
proviso to,
Proviso, Manus, proviso also. What the proviso?
Officers and servants.
MV Dixit is watered down by adding proviso.
No,
MV Dixit says, court said not, upgrading or downgrading, they must comply. Section
That
3.
was in respect of post of account superintendents in PWD. And Chitra is subsequent to MV Dikshit. And Chitra dealt with judicial service specifically and held, relied on Bal Mukund Shah, 3-judge bench judgment of Supreme Court. And section 3, proviso also provided that in respect of officers and servants of the High Court, not in respect of judicial officers.
officers should refer to judicial officers.
Yes, because we are dealing with the post of district judges. Proviso deals with High Court employees. How many? What is the cadre strength of registrars? What is the cadre strength of court officers, judgment writers, senior judgment writers, joint registrars? Those are required to be made by a rule by the Chief Justice of the High Court under the proviso.
Who appears for the High Court? Yes, please.
High Court, Mr. Naganand.
This question we want an
Yes,
answer.
High Court also. Rules itself says.
This question we want you to answer.
Yes.
Because there appears to be some explanation. You have to come forward. 1. 2, just make a note. At an appropriate time, we may point out.
Yes.
The administrative committee notes
Yes.
at the time of promotion.
Yes.
If you feel it is not to be shared, you can give it in a sealed
It
cover.
is ready, madam. Today we will show it.
That's it. This point is a matter because both sides are arguing on the point of Cadre.
Yes.
So this 3B proviso, you'll have to take your stand.
Yes.
Yes.
But the officers and employees of the High Court, they are governed by, officers and servants is governed by Article 229, which says that appointment shall be made by Chief Justice or such other judge or officer, etc. But officers and servants of the High Court cannot be confused with judicial officers like civil judges, senior civil judges, and district judges. I have also placed on record the Karnataka, the Civil Courts Act, that is Karnataka City Civil Courts Act, at page 643 of my compilation. The Act starts at page 652. Section 2B at page 652 defines civil court means a district court of a senior civil judge, or a court of a civil judge. All are included in the definition of civil courts. But when it comes to cadre strength, it is governed by Section 8. Section 4 says there can be more than one district judge court for a district. Section 5, appointment, it deals with. At Section 8 is the provision of law which deals with the cadre strength. What it reads is, number of senior civil judges and court of a civil judges to the court of a senior civil judge or civil judge. The state government may, in consultation with the High Court, fix and from time to time vary by notification the number of senior civil judges to be appointed for the court of a senior civil judge and number of civil judges to be appointed. Here notification is required, civil judges and senior civil judges. The act itself is not insisting on such a requirement when it comes to the category of judges called district judges or additional district judges.
It is not required.
It is not required because it is not stipulated. What the legislature has not prescribed, court cannot read that such a requirement into the law, because legislature is opposite us, Vidhan Sabha. We are here only to interpret what they say. We cannot make the law except in Abdul Rahman Antulia's case, first judgment of 5 judges, it made the law saying that Antulia shall be tried by High Court instead of a special court. Review of it was sought. 7 judges sat and reversed it, saying that we are not here to make the law, we are only to creation of jurisdiction, etc. is the prerogative of the legislature.
So in this judgment, there was a reference to the notification. Is it your submission that this reference is to this?
That was regarding civil judges,
Which is not applicable to the.
which is not applicable. What I relied on that judgment for the proposition that Civil Services Act or a rule made under Article 309 would not be applicable per se by itself. And that submission is strengthened by the provisions of the Karnataka Karnataka Civil Courts Act, which at Section 8 requires notification of cadre strength for senior civil judges and civil judges, and not for district judges.
Yes.
Let us look at it from pragmatic angle also, my lords. If a person is appointed as a district judge against a post which is non-existent, his salary bill will not be cleared by the advocate general, the accountant general. In fact, even to settle the pension of the judicial officers promoted from district judiciary to High Court, in respect of one learned judge of this honorable court, I had to argue for about 5 years to get him a judge, to get him, because the situation was very alarming. By becoming a High Court judge, he would have drawn lesser pension than what he would have drawn had he continued as district judge till retirement. Accountant General was very, very accommodative in as much as he came for discussion to this court in the chambers. There, the accommodation ended. After going to office, he wrote an order saying that you are not entitled for the pension you are claiming. Then by writ, I had to get that relief saying that by becoming a High Court judge, you are reducing his pension. This is outrageous. Then they modified the last 12 months salary that you have drawn. It has to be taken as High Court judge of the salary drawn as a High Court judge, because they were telling very hilarious argument. For the period you have worked as district judge, you will get pension under state rules. For the period we have worked as High Court judge, you will get pension under the central rules. That was the catch. Here it is nobody's case that Accountant General is not satisfied that the post has been created or has not been created. Of course, this is we have to have a look at the ground realities. Therefore, my lords, don't try to argue the point not raised.
Yes.
Then I was proceeding with reading of judgment in C.B. Chitra. I was at page 132, end of paragraph 17. Kindly read para 18. In the light of the pronouncement made by the apex court in Balmukund Shah's case, the judgment cited by the learned counsel for the petitioners in the case of Madan Mohan Chaudhary, which pertains to compulsory retirement of a district judge, wherein it is held that judicial officers are essentially government servants, and in the case of Pradyut Kumar Bose versus High Court reported in 56 SC, where the question was whether a High Court employee is a member of the public service or civil service, was dealt with in Tulsiram Patel's case, wherein the meaning of the term employed in civil post is dealt with, do not come to the aid of the petitioners. Even if it is a civil post, it will not apply. The further reliance placed by the learned counsel for the petitioners on the judgments in Jogindranath, State of Bihar versus Madan Mohan Prasad, and B.S. Yadav versus State of Haryana, All India Judges Association versus Union of India. That is where the Supreme Court said no experience is required. Also will not support the contention of the petitioners in view of the law declared in Balmukund's case. Then again, Balmukund Shah. Now it must be kept in view, the B.S. Yadav observations are made in the light of second part of article, which expressly saves law regulating conditions of already recruited judicial officers and who are functioning under the control of the High Court under Article 2. Once the very same article permits the limited field for operation for regulating conditions, as already this found, or by appropriate legislation, it cannot be said that these observations have laid down, even impliedly, that while recruiting judicial officers either at the grassroots level under Article 234 or at the district level under Article 233, any legislation can be enacted by the legislature of that governor by independent exercise of his rule-making power can make such a provision. No rule made by the governor would be applicable. I omitted reading Balmukunsa because it is a very lengthy judgment and then, my lords, at page 15, last paragraph of my synopsis. Secondly, there is how the paragraph starts. The matter is governed by special law, namely the Karnataka Civil Courts Act 1964, which does not require issue of notification in the matter of creation of post of district judge. Then I have a problem with they narrated what are the provisions of the act. At para 16, I have extracted text of section 8. The state government may in consultation with the High Court fix and from time to time vary by notification number of civil judges to be appointed or number of civil judges to be appointed, senior civil judges. A notification is also to be issued under section 13 for fixing local limits of the jurisdiction. Karnataka Civil Courts Act being a special enactment relating to constitution, powers and jurisdiction of civil courts and definition of civil courts include district court. It prevails over the general enactment Karnataka State Civil Services Act 1978. This is independent of CV Chitra, which is a special enactment. Dealing with civil judiciary, there is a special enactment. And there is no question of any notification required. Then, my lords, last but one paragraph at 17, after referring to the various orders passed by the High Court. In these circumstances, insisting on a notification is chasing the shadow, ignoring the substance. Creation of a court to be headed by district judge or additional judge automatically means creation of a post of district judge or additional district judge is what the common sense tells. As the Supreme Court put it, common sense is not enemy of court sense. I don't want to again read that Kulasreshta because I have already taken my lords through that judgment. Then, my lords, straight away, my lords, we can come to page 19. I say that 1962 rules did not contain a quota. 1962 rules is extracted. Page 19, last proviso at page 20, provided that as nearly as maybe 33 and 1/3% of the number of posts in the cadre of district judges shall be filled or reserved to be filled by direct recruitment. It does not contain a quota, I said. Then again, 83 rules and all I have narrated, which I have already argued in extenso. Then, my lords, the posts that were excluded by Honorable Judge Rajesh Rai are on the ground that the posts were created only for a particular period, not thereafter. For that, the Supreme Court's categorical answer is, cadre strength consists of not only the permanent posts, but also temporary posts. Suppose a temporary post is created today. It has to be held by a district judge. Appointment is made. A regular promotion is made. After 1 or 2 or 3 years, that post is that court does not stops functioning, or the purpose for which the post is created is served. Then it cannot be said that temporary court has gone, therefore temporary post has gone, but regular district judge also will go, because his promotion is not temporary. His promotion is regular. Kindly see Bishan Sarup Gupta, that is judgment volume number 1, page 61. Bishan Sarup Gupta, this is a constitution bench judgment at page 61. Para 18. At page 68. It is feebly contended on behalf of the direct recruits that the quota rule should be to only vacancies in permanent posts and not temporary posts. This contention is not accepted either by the promotees or the department. There is nothing in the rules of the quota rule of 1951 which says that vacancies must be vacancies in permanent posts. Indeed, vacancies must be permanent vacancies. That is, say vacancies not for a few days or for a few months or otherwise adventitious. This is the only test. It should not be for a few months or few days. Anything more than a few months and or a few days, it will be taken into consideration as cadre strength. The whole has consisted of permanent and temporary vacancies posts for years. Permanent vacancies, therefore, likely to take place both in the permanent post and in the temporary post. In fact, Mr. Dutt in his affidavit had clearly alleged in paragraph 26 of the affidavit that all the direct recruits from 1940 were initially appointed against temporary posts, and even at the time of filing of the affidavit, direct recruits were being appointed against. We therefore find no sufficient warrant for the contention that the vacancies referred to in the quota rule are vacancies only in the permanent posts. The only deviation from this proposition is made in VV Badami, where the recruitment rule and the cadre strength notification itself did not take into account the temporary posts. And a finding was recorded in VV Badami that cadre consisted in that case only of permanent posts. It is not that cadre cannot consist of any. Now the latest is that the collegium has recommended ad hoc judges also for the High Court. It will be for a period of 2 years.
But ex-cadre that is.
But
Nothing to do with it. It has nothing to do with it.
no. I am saying, my lord, where there is arrears of work, even beyond the permitted strength of the High Court judicial, the judges' strength, ad hoc judges can be appointed. Even in the, I think, Lordship Justice Satyanarayan Raju from Andhra Pradesh, he was appointed in the Supreme Court as ad hoc judge. Then later years, Lordship Justice Reddy, expert on criminal law, I forget the full name. He volunteered to work after retirement as an ad hoc judge to clear the arrears on the criminal appeal side in the Supreme Court. And it goes to his credit. Therefore, my lords, then, my lords, Lordship Justice K. Jayachandra Reddy. Then, my lords, kindly see, A.K. Subramanian. A.K. Subramanian, I will be relying on for 2 propositions. That is, A.K. Subramanian is judgment number, volume 3, judgment number 19, that is commences at page 518. This judgment I would be relying on for two propositions. One is cadre strength. Cadre consists of both permanent and temporary posts. And another for the proposition that merely because of direct recruitment not taking place, promotions cannot be stopped. What the Supreme Court says is merely because one stream is not operated, you cannot make other streams sterile. Direct recruitment, as we know, it takes long time.
That is the problem with this quota rota rule. And when you say you do it in 1 year,
Yes, that is the thing, Manoj. That is the reason, perhaps one of the reasons why our High Court has not adopted rota rule. What happens is, if rota rule is applied, if direct recruitment takes place every year, there will be no difficulty. But direct recruitment takes place once in many years. That is our experience. Then what happens is, a schoolian will become senior to a person who entered the cadre. A person perhaps who has joined law course today, he would become senior to a promoted district judge of 5 years vintage. Though Supreme Court said, with due respect to Supreme Court, though it said that all the problems of seniority are because of not having quota rota rule, follow R.K. Sabharwal. We have seen how that rota rule operates. The rota rule is a direct assault on golden rule of length of service in service jurisprudence. There can be aberrations, but golden principle of determining the seniority is length of service rule. This is the phrase used in one of the judgments of the Supreme Court. No, Manoj, in A.K. Subramanian, kindly take para 20, that is at page 527. Now the question which arises for consideration is, what is the meaning of the words vacancies in the grade of executive engineer as used in the aforesaid paragraph of Rule 4.2? When does a vacancy in the grade of executive engineer arise? To answer this question, it is necessary to ascertain what are the posts in which are the grade of executive engineer consists of. For the vacancies can only be in the posts in the grade of executive engineer. The word grade has various shades of meaning in service jurisprudence. It is sometimes used to denote a pay scale and sometimes a cadre. Here it is obviously used in the sense of cadre. A cadre may consist of only of permanent posts or sometimes, as is quite common these days, also of temporary posts. Then it relies on Bishan Sarup Gupta. Then, Manoj, about the sterility of one of the sources because the other source has not been operated. The very same judgment at paragraph
23?
23.
minutes.
23.
Somehow I always miss that particular paragraph. Para 20 occurs to my mind very. That is, my lords, about the control. What is the control?
Page 529.
Huh?
Page 529.
Page
529.
529 judgment 589.
529.
Page number
529.
Yes, my lords, page number 5.
Para 29.
That why ಎರಡು ಕಡೆ ಹಾಕಿದ್ದೀವಿ.
Para
29. Summarize this first.
relevant at 5:30.
It is submitted by the respondents. That is, my lords, para 23. Sorry, I was looking to some other para 23, my lords. It is submitted that by the respondent that 1/3 quota cannot be filled unless the 2/3 quota was exhausted. This, in our opinion, the view will introduce a sterility in the quota rule so far as the promotees are concerned. Their hopes and aspirations cannot be related to the availability or non-availability of direct recruits to fill the 2/3 quota. Each quota will have to be worked out independently on its own force. The word rest in the quota rule cannot be pressed into service to defeat the object of the rule, coming in aid of advancement of prospects of promotees in the hierarchy of the service. Therefore, promotion need not wait for direct recruitment to take place. Then, my lords, I move on to the proposition that my seniority will have to be determined on the basis of the rule in force on the date I entered the cadre. Subsequent change of rule will not impact my seniority. For that proposition, my lords, authoritative judgment is P. Mohan Reddy versus A. Charles. Charles, judgment number 11 at page 180, volume 1. This is also by 3 judges bench, para 17, my lords, at page 193.
180, page 180.
A conspectus of the aforesaid decisions of this court would indicate that even though an employee cannot claim to have a vested right to have a particular position in any grade, but at the same time, all the same, he has the right of his seniority being determined in accordance with the rules which remained in force at the time when he was, paragraph 17 at page 193. But all the same, he has the right of his seniority being determined in accordance with the rules which remained in force at the time he was born in the cadre. Actually, it should be, he was onboarded into the cadre. It is. The question of redetermination of seniority in the cadre of the basis of any amended criteria or rules would arise only when the amendment in question is being made retrospective. Here, the rule itself has not been made. Then what are the dangers of retrospectivity? That is further stated. If the retrospective of the rule is assailed by any person, then the court would be entitled to examine the same and decide the matter in accordance with the law. If the retrospective of the rule is ultimately struck down, necessarily the question of redrawing of the seniority list under the amended provisions would not arise. But if, however, the retrospective is upheld by a court, then the seniority could be redrawn in accordance with the amended provisions of the employees who are still in the cadre and not those who have already got promotion to some other cadre by that date. Here, if you redraw the seniority list from the year 1983, several of them have become High Court judges and retired. How far it can go is indicated here. In fact, this is what was laid down in SS Bola. Legislature made a retrospective amendment. That amendment was upheld, but it said those who have secured promotion on the basis of earlier seniority, their seniority and the promotion shall not be disturbed. There is a same SS Bola without referring to that. It has been, that is also by a 3-judge judgment. Further, a particular rule of seniority having been considered by the court and some directions having been given, the direction has to be followed in the matter of drawing up the seniority list until unless a valid rule is, etc. etc. The rest of the thing is not necessary. as was done in Bola's case. It may be further stated, if any rule or admin mandates drawing up of senior determinacy within any specified period, then the same must be adhered to unless any valid reason is indicated for non-compliance with the same. This rule is violated by everybody in the Karnataka state, including the High Court in drawing up, because Rule 10 of the seniority rules requires drawing up of seniority list every year. But the principle is that seniority once determined cannot be changed. Annual exercise is only for updation and not upsetting. And then, my lords, all this was told by our High Court way back in the year 1973. That is judgment number 12,
Page 160.
page 169.
169.
We have another 10 minutes today and then we'll continue on Monday.
Very well.
Another 10 minutes. That's
And
some-
I'll conclude this point. There is only one more judgment I have to take, my lords. That is, kindly take judgment at page 169. Yes, Shyam Sundar versus Union of India. In fact, my lords, this judgment is authored by Lordship Justice Jagannath Shetty, Chairman of the First Judicial National Pay Commission. There, my lords, I would say, whatever I may argue, or whatever the central government may, the state government may argue, whatever High Court may argue, or whatever my learned friend may argue, ultimately seniority has to be determined on the basis of the rule and nothing else. That is what the same thing that was said later in Mohan Reddy. They also, here also the same thing is said. Para 12, page 176. We turn from that to the second contention, whether the petitioners have a right to count their seniority the period commencing with the date when they first joined duties as ACF. For the respondents, it was urged that the petitioner were probationers and the Government of India have taken a uniform decision to exclude the probationary period of the allottees while integrating their services. We do not think that the question before us could be decided on the basis of an alleged uniform decision of the Government of India. It cannot also be determined on the allegations and counter-allegations of the parties. In our view, it has to be resolved with reference to the rules regulating the petitioner's recruitment and their conditions of service. It is a dominance of the rules and not dominance of the parties. Even if the High Court were to say this is the uniform practice, my lords need not be hamstrung by that. Ultimately, it is the rules. Then, my lords, about quota, point number 6 at page 24, I have already argued that all the two judgments plus also the judgment of the Supreme Court in O.P. Singla, I have extracted. Then, my lords, that takes me to proposition number 7 at page 27 of the synopsis. I would proceed from that stage on the Monday.
Arguments remain inconclusive. List for further hearing Monday at 2:30.
Monday morning, my lord?
2:30.